Thanks, Deputy. Okay, please be seated. The state may call its next witness.
Thank you, Your Honor. The state would call Professor Seth Stoughton.
Professor, good morning. Will you please come forward and then stand behind the witness chair, which is right next to me. Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this case?
I do.
Please have a seat. And would you please remove your mask? And state your full name and spell it.
My name is Seth Wayne Stoughton, SETHWAYNE, STOUGHTON.
Okay, thank you. A couple of things to keep in mind when you're testifying. The court reporter that's sitting right in front of you is taking down everything that's being said. Therefore, you have to answer with a yes or a no instead of shaking your head, and don't say uh-huh or uh-uh.
I understand.
All right. Only one person can talk at a time. Wait until the question's finished before you answer. If an objection is made, you've got to stop talking immediately and don't answer the question unless I tell you to. If you don't understand the question, please let the questioning lawyer know. Okay?
Thank you.
Counsel?
Thank you, Your Honor. Professor Stoughton, can you tell the jurors how you are currently employed?
I am an associate professor at the University of South Carolina School of Law and an affiliate with the Department of Criminology and Criminal Justice.
And that department, is that also at the University of South Carolina?
It is, yes.
So the law school plus like an undergrad department?
Yes, my primary appointment is at the law school. I have an affiliate or courtesy appointment with the Department of Criminology and Criminal Justice because of the nature of my work.
And how long have you been serving in those roles?
The affiliate appointment is relatively new, the last year or so, I would say. I've been a law professor at the University of South Carolina since 2014, summer of 2014.
And so do you teach classes at the law school?
I do, yes.
Do you teach classes at the undergraduate part of it as well?
I have taught a course at the university's honors college, but it's not part of my normal teaching rotation.
So what classes do you teach at the law school?
I teach criminal law, criminal procedure, police law and policy class, a regulation of vice seminar. I have taught a class called Advanced Topics in Criminal Law, but only once, and I don't think I'll go back to it.
Do you also conduct research in that position?
I do, yes.
And what kind of research do you do?
I study policing, police culture, police regulation, policies, behaviors, essentially the rules and regulations, both formal and informal, that we use to get officers to do what we want them to do and to not do what we don't want them to do.
I'm going to back up a little bit and go into your educational background.
Sure.
And did you obtain an undergraduate degree?
I did, yes.
And where was that at?
Florida State University in Tallahassee.
Do you recall when you completed that degree?
I do. I started that degree in 1998, and because I'm a little slower than the average bear, I finished it in 2008.
And so most people don't spend 10 years completing their undergraduate degree.
It's a long time to get a 4-year degree in.
Was there something in the middle that interrupted or slowed down your progress?
Yes, in the first semester of my junior year, I went to the police academy and served as an officer, later switched jobs to become an investigator for a state agency. And the regular working hours as a state investigator allowed me to finish that 4-year degree.
So did you work as a police officer?
I did, yes.
And where did you work? What department?
The Tallahassee Police Department.
So that's Tallahassee, Florida?
Yes.
Is that where Florida State is?
It is.
And so when did you start working there?
I started there. I began the employment process in late 2000 and was employed there in March 2001.
So can you describe for the jurors what you went through training and education-wise to become a police officer?
Sure. I attended the Pat Thomas Law Enforcement Academy, which is our pre-service basic academy training. That was 5.5 or 6 months. When we finished, the academy that I attended was not agency specific. There were officers from a number of different agencies, including my own, who went there. So when we finished the academy training, my cohort and I had 4 to 6 weeks of additional classroom training at my particular agency, then a 3.5 or 4 month field training program before I was what they called solo and on my own as an officer in, that would be November of 2001.
And what were you assigned, what duties were you assigned when you started for the Tallahassee Police Department?
I was with the Uniform Patrol Division. It's our uniformed beat cops.
So what did you do as a patrol officer?
Over the 5 years I was with the agency, I worked in 2 of our 3 districts. We broke the city into 3 different districts, Alpha, Bravo, and Charlie. I worked in primarily in our Charlie district and our Bravo district. The primary jobs of a patrol officer are responding to calls for service, self-initiating activity like initiating traffic stops, conducting field investigations, making arrests, writing up information where you can't complete an investigation so that an investigator can pick it up and conduct additional investigation. I also had some additional duties not specific to my patrol function. I trained officers on report writing. I spent 2 years on our special response team, served on some committees doing policy writing for new technologies, among other things that the agency was adopting.
Did you have any other special assignments during those 5 years?
I taught for the city community self-defense classes, child molestation and abduction prevention classes. There would have been a bunch of things that came up on sort of an ad hoc basis, but in terms of repeat assignments, it was basically those around my core patrol officer function.
Were you licensed as a peace officer during that time?
Yes.
And did you receive training as a police officer?
Yes, both pre-service, that is before I was in a real uniform and in a car, field training, and then as an officer, annual in-service training.
And was that required to keep your license in Florida?
Yes, there were a certain number of hours that you had to complete every 4 years to keep your certification, and then by policy, my agency had additional training that it required us to go through annually.
And I think how long did you work there then as a police officer?
I left full-time at the end of October 2005. I stayed on as a reservist, which is a part-time officer, for about another 6 months until mid-2006.
And during that time that you were working as a police officer, did you have occasions where you had to use force on individuals?
Yes.
Did you have incidents where you had to arrest somebody and take them into custody?
Yes, quite a few.
Did you have occasions when you had to handcuff individuals?
Sure. Yes.
And did you have to write reports?
Lots of reports. Yes.
Were those reports reviewed by others in your department?
Yes. Either a sergeant or acting sergeant, and then for some reports, our lieutenant or watch commander would review reports and approve them.
So you told the jurors that at one point you left that job. Where did you go?
I left the city police department for a position as an investigator with Florida Department of Education's Office of Inspector General, sort of like the internal affairs for the Department of Education.
And what did you do for that agency?
I was an investigator assigned to a mix of criminal and administrative investigations. The administrative investigations would be violation of department policy, anything from sexual harassment to, there were a ton. Someone who was running a real estate business out of their state office, for example. The criminal investigations, we had some that were in-house, involving criminal investigations of department employees, someone who had stolen a check, for example, as well as investigating criminal violations of Florida's private school tuition voucher program, which was associated or run through the Department of Education rather than local school districts.
Do you recall how long you had that job?
I was there from November of 2005 until June or July of 2008.
So while you were working there, did you then resume your education?
I did, yes.
Why is that?
Because I thought it was sort of sad that I was going on 7, 8, 9 years of not finishing a 4-year degree. Finishing my education was something that was important to me, something that was important to my parents, something that was important to my career trajectory. So definitely something that I'd always intended on finishing. I just didn't have the luxury of it doing shift work with the department.
And so you told, I think, the jurors earlier you completed that degree in 2008. Is that right?
Yes.
And what was that degree?
It was a bachelor's degree in English with a focus on literature.
And so then what did you do after obtaining that degree?
I matriculated, which is a fancy academic term of I went to law school.
And where did you go to law school at?
The University of Virginia School of Law.
And did you graduate from law school?
I did,
What
on
year?
time even.
And how many, or when did you graduate from law school then?
2011.
And so did you go to work in the legal field then after graduating?
I clerked for a year, which is working for a judge, and then had the opportunity to pursue an academic fellowship, which I did prior to taking my tenure track position at the University of South Carolina.
And what is an academic fellowship? What kind of stuff do you do?
In the legal field, you can think of an academic fellowship as a little bit like what a postdoc would be in other fields. It gives an aspiring academic time to research, to write, to develop the body of written work that you need to get an entry-level tenure track job.
How did you get interested in doing that?
When I was in law school, I initially had no intention of staying in the criminal law field or doing anything with policing, but taking criminal law, taking a criminal investigations class, which is now the class I teach under the title Criminal Procedure, really got me interested in studying the rules that I had used as an officer from an academic and particularly a legal academic perspective.
And so what did you focus your research on during that fellowship?
On policing.
And after that fellowship, what did you do in your career?
In the second year of the fellowship, I went on the academic entry-level hiring market, got my tenure track job at the University of South Carolina, and ultimately accepted that and have been there ever since.
Now, have you authored any scholarly publications?
Yes, quite a few.
Can you generally describe for the jurors what they are?
I would love to. Yeah, I've written a number of academic articles on policing, everything from how the Supreme Court develops Fourth Amendment rules that regulate policing to issues of police culture and the effect of police culture on the regulation of officer behavior, some aspects of history of policing. Over the last few years, my focus has been much more on tactics and the use of force. I've written articles on tactics. I've written book chapters on reviewing use of force. I have, with a couple of co-authors, a book on evaluating police uses of force. So that's been my primary focus over the last few years.
So this is going to seem really redundant, but what is the title of the book you've authored?
It is creatively titled Evaluating Police Uses of Force.
And when did you publish that book?
That was published in April of 2020.
And are there other authors involved in that book?
There are, yes.
Two other authors, correct?
Yes, Jeff Albert and Jeff Noble.
Professor Stoughton, are you a member of any professional organizations or associations?
I am, yes.
Can you describe those to the jury, please?
Sure. I'm a member of the American Society of Evidence-Based Policing, which endeavors to take empirical work and bring it into policing as a predicate for good policy and decision-making. I'm a member of the International Association of Chiefs of Police in the Legal Officers section. I'm a member of the American Law Institute. I'm a member of the I'm a fellow of the American Bar Foundation. There are probably some others, but I don't remember them offhand.
So are you a lawyer?
I am a lawyer. I do not practice as a lawyer, but yes, I'm barred in the state of Virginia. Thank you. I'm also a member of the Virginia Bar.
Do you also consult with or are consulted by law enforcement agencies?
Yes.
Can you describe that for the jury, please?
Sure. So I have done training for law enforcement agencies on a range of different topics, from doing presentations at the Federal Law Enforcement Training Center or the command staff at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, Federal Inspectors General, training for the command staff of the Kansas City, Missouri Police Department. The trainings or focus of what I come in and talk about can vary. Sometimes it's on setting up a robust body-worn camera program for an agency that's considering that, putting together a use of force review process. I serve. This might be an association membership. I'm not sure how to categorize this one, but I'm one of the members of the Civilian Advisory Council for the Columbia Police Department. In that capacity, I provide some consulting to that agency, or at least input to that agency, as well as doing a range of talks for other law enforcement actors, not traditional police agencies. For example, last week I was giving some talks and training to the state attorney's office in Jacksonville, Florida.
That's my next question, is have you done some speeches or presentations to groups in this area?
I have, yes, quite a few.
And can you just tell us what kinds of groups you've given presentations to?
Sure. I've spoken before the Fourth Circuit Judicial Conference, a conference of judges and prominent lawyers in the Fourth Judicial Circuit, Federal Circuit, to the American Judicial Association, to judicial conferences in half a dozen or more states. South Carolina is the easiest one, but Ohio, North Dakota, kind of all over the place. To professional organizations like the South Carolina Bar, for example, to community groups or other non-legal professional organizations. All of the talks or training have been on or about policing and various topics within that.
And Professor Stoughton, have you been retained to offer expert opinions in this case?
I have, yes.
And have you been retained as an expert before this case?
Yes.
And that is an expert in the area of policing and law enforcement?
Yes. Police procedure, investigations, tactics, and the use of force primarily.
And how many times have you been retained as an expert?
I believe my current retentions are in the mid-80s. I think 84, but I may be off one or two.
Have you testified in court as an expert?
I have, yes.
And can you describe what courts you've done that in?
Yes, I've testified in both federal courts and state courts in the context of both civil matters, civil lawsuits, and in criminal proceedings.
And when you are retained, you were retained by the state in this case, correct?
Yes,
When you are retained, do you charge a fee for your services?
I do.
And what are your fees?
It will depend a little bit on the nature of the entity that retains me. In this case, I have a $290 an hour fee, and on days when I'm expected to testify, a 10-hour flat rate.
And to date, have you been compensated for your work in this case?
Yes, I've been compensated for hours worked, I think, through November.
And approximately how much have you billed so far?
I would have billed, I believe, 34 or 35 hours, and I would have to do that math somewhere in the area of $9,000, I believe.
When you have been retained, have you always reached an opinion favorable to the party that hired you?
No, certainly not.
Why is that?
Your Honor, this is irrelevant.
The objection is overruled. You may answer.
Can you repeat the question, please?
Why is it that the opinion you reach is not always favorable to the party that hired you?
It depends on the facts of the particular case. When a party hires me, when a litigator in civil or a criminal proceeding hires me, they're hiring me to apply a professional standard, that is to compare what an officer or officers or an agency did and to contrast that with the standard that you would expect an officer, or rather that I suppose would expect an officer to meet. Whether they've satisfied the professional standard of care, as the term sometimes is used. And in some cases, some number of cases, my review simply has not been helpful to the attorney who's hired me. Sometimes that's a plaintiff's attorney who is suing an officer, and my opinion is that the officer acted reasonably and appropriately. Sometimes that's a defense attorney who's defending an officer in a civil or criminal lawsuit, and my opinion is that the officer acted inconsistently with generally accepted police practices. The exact reasons, of course, would depend on a particular case, but in essence, I'm not being retained to give an opinion that is favorable. I'm being retained to review and give as objective an opinion as can be managed.
Did you seek out the state to work on this case?
No.
And have you, in fact, arrived at some opinions regarding the conduct involved in this case?
I have, yes.
I ask you about the process you go through to arrive at those opinions. Can you first explain how you start when you're retained in a case?
Sure. So the first thing that I need to do is really understand the body of evidence or information that applies. I need to get all of the information, either all of the information in the case or all of the information that I or the attorneys who hired me agree is relevant to the opinions that I would be forming. So the first step is really gather all the information and start looking through it.
And did you gather some information in this case? Were you provided information in this case for that purpose?
Yes, I was provided with a great deal of information in this case.
Can you just generally describe for the jury what kinds of information you did receive.
Sure. So in this case, there were several thousand pages of written documentation, training records, personnel records, among others. There were videos from officers' body-worn cameras. There were videos from squads, from police vehicles, or in-car camera systems. There were interviews that had been conducted of some of the parties involved in the incident. There were still images, crime scene photos. There were cell phone records. There was additional information about the crime scene using sort of a three-dimensional laser modeling technique. I believe I received all of the file in this case.
Was that information, in your opinion, adequate to arrive at opinions in this matter?
Yes, it was.
In your work in this field, do you commonly review body-worn camera videos?
Yes, quite often, both as a consultant in the context of specific cases and also as a trainer and educator. One of the trainings that I have done most frequently is educating investigators, prosecuting attorneys, other parties on how to review and interpret video footage, particularly body-worn camera footage, and especially in the context of use of force investigations.
Have you done any research or publication in the use of body-worn cameras?
I have, yes.
Can you just briefly describe that for the jurors?
Sure. I have, I believe it's a 2018 article on police body-worn cameras that identifies the potential benefits of the technology, the limitations, both the limitations of the technology itself and the limitations that we have as humans viewing video footage. I have a chapter insert in a book by Eli Malm and Michael Wright, two criminologists, on body-worn camera footage, specifically on the review procedures of watching body-worn camera footage.
I think you just mentioned two authors.
I did, yes.
Can you spell that first author?
Yes, Michael Wright, both common spelling, and Eli is A-I-L-I, last name M-A-L-M, I'm pretty sure.
And is it helpful to have body-worn camera videos of the incident?
It is, yes. Body-worn camera footage can provide information that you simply would not get from another source. You have to be a little bit careful in relying too heavily on it, because body-worn camera footage, like anything else, is just one more piece of evidence to compare and contrast against other pieces of evidence. But it can be extremely valuable in the right case.
Is it also helpful to have multiple different body-worn camera videos of an incident?
Absolutely. The more video you have, the more insight you have into what happened in a particular case. Information that may not be clear on one video because of an obstruction, for example, or because an officer is moving, may be clearer on another video. Just like having multiple statements is often more helpful than having a single statement, having multiple videos allows you to draw firmer and sometimes more conclusions than just having a single video.
So in reviewing all that information that you obtained, did you rely on your training and experience when reviewing and interpreting those materials?
I did, yes.
Now, when you begin working on a case, you told us you review the materials. When you get around to analyzing the case itself, what is the first step that you undertake when working on a case?
Sure. So in a use of force case or in a tactics case, the frame that I have to use for analyzing it is the perspective of the reasonable officer in the position of the actual officer. So if you sort of imagine pulling the actual officer who is there out of the picture and putting in this idea or this construct of the reasonable officer, I have to identify what information would have been known to the reasonable officer on the scene. It wouldn't really be fair to anyone involved to assess an officer's actions using information that was not available to them or someone in their position.
And then what is the next step that you do in the process of analyzing the case?
After identifying the information that's available to the officer, the reasonable officer on the scene in the officer's position, the next step is identifying whether there was some threat that could justify a use of force. And I'm using a use of force a little bit carefully here. The question isn't yet whether a particular use of force was justified. It's just whether there is some threat that justifies some use of force in response.
And then what is the next step that you do?
So after identifying the foreseeable effects of the threat, then the question the question turns to the officer's response. It requires looking at the officer's actions and identifying what are the foreseeable effects of the officer's actions. An officer's use of force can have different effects in different circumstances. So what could be a relatively low-level use of force in one case might be a relatively high-level use of force in another case. I have to look at the facts and circumstances, again, through that framework of a reasonable officer on the scene, and identify what the reasonable officer would have thought the likely effect of their actions would be.
And for that last step in the analysis, what standards do you apply in making that determination?
The ultimate standard that I'm using is the professional standard within policing. Policing draws on, as an industry, a bunch of different standards. It draws on some Fourth Amendment law, it draws on state law, it draws on some research, it draws on historical practices within policing. So what I'm looking to determine what the foreseeable effects of force are, it's really what would the professional officer in this situation have perceived, what would the reasonable officer in this situation have thought the foreseeable effects are going to be. That would include the training that officers get, that would include agency policies, anything that helps inform that expectation on the officer's position.
If an agency has policies, how does that contribute to the standard you've just talked about?
Sure. So policies are effectively rules or guidelines that help provide guidance to officers in the performance of their duties. If officers did everything perfectly all the time, you wouldn't need policies to tell them what to do or what not to do, right? You could just send them loose and everything would be fine. So when you're analyzing, or when I'm analyzing, what the foreseeable effect of a particular use of force is, for example, one of the inputs, one of the factors to consider is what the officer has learned at their agency about that particular use of force. Sometimes there are things that I would describe as generally accepted in policing. That is, policing as an industry knows about something, but the officers in this case may have been badly educated. I say this case to refer, of course, to the hypothetical that I'm talking about, not any case in particular. If officers just simply don't know, in fact, I had a small role working on a case like this out of South Carolina, if officers simply don't know about this risk because it's outside the scope of their policy and training, then although there might be a violation of generally accepted police practices, that would fall more on the agency than on the officer. On the other hand, when there are risks that have been identified in policy or in an agency's training, then it should be clearer that the officer has some awareness, or certainly should have some awareness, of what those foreseeable effects or those risks are.
Are you familiar with an organization called Lexipol?
I am, yes.
And what is Lexipol?
Lexipol is, until relatively recently, Lexipol was primarily involved in creating and marketing policy manuals for police agencies. An agency could go to Lexipol and purchase off the shelf a set of policies that it could then take and append and revise as the agency saw fit. A A little more recently, Lexipol has gotten into the training and commentary space. They've purchased a media publication website that used to be Police One and is now called Police One by Lexipol, as a way of publishing op-eds or information to a police-oriented audience.
So is obtaining policies, foreign policies from Lexipol a reasonable thing for agencies to do?
It certainly can be, yes. Lexipol refers to case law in the specific state where the agency is located. It refers to Supreme Court or Federal Circuit case law. Lexipol tries to take some of the work of creating policies, out of the process of creating policies. It tries to provide a more standardized basis for agency policies, both in terms of content and formatting. Although I think there are reasons that agencies might want to particularize some policies much more closely than sometimes they do with Lexipol, as a way of sort of setting a fundamental baseline. I think the Lexipol policies are generally consistent with accepted police practices.
Now, you mentioned earlier the constitutional standard for police uses of force, correct?
Yes, one of the factors or one of the inputs that informs the professional standard within policing is certainly the constitutional law and the Fourth Amendment.
And what is that standard? Can you describe that? Give the jurors a brief primer about that, please.
Sure. So in 1985, the Supreme Court decided a case called Tennessee v. Garner, which was a deadly force case. And in that case, the court held that for officers to use deadly force without violating the Fourth Amendment, officers had to have probable cause that the subject against whom force was used presented an imminent threat of death or great bodily harm to the officer or someone else. 5 years later, in 1989, 4 years later, in 1989, the Supreme Court decided a case called Graham v. Connor. In that case, the court held that with regard to other uses of force, what are referred to generally as less lethal uses of force as opposed to deadly force, although the court didn't use that language, that in order to comply with the Fourth Amendment, those uses of force must be objectively reasonable. It provided some guidance on how to make that assessment, as well as the framework that I mentioned before, the question of whether an officer acted in an objectively reasonable manner is a determination that's made from the perspective of the reasonable officer on the scene.
And were there some particular factors the court drew out in Graham that informs the determination of the reasonableness of force?
Yes, the Supreme Court identified a series of three non-exhaustive factors that are now referred to often as the Graham factors. That's the severity of the underlying crime, whether the individual is attempting to flee or evade arrest by flight. Whether the individual is actively resisting or attempting to evade arrest by flight, and whether the individual presents a threat of harm to the officers or others.
Now, in this, from both of those cases comes the word threat, correct?
Yes.
And based on your training and experience in this field, and when you use the term threat, how would you define threat?
Sure. So a threat, or particularly the concept of imminent threat, can be distinguished from another concept that I'll refer to as risk. A threat exists, or a threat is imminent, when the reasonable officer on the scene would perceive the individual in question as having the ability, opportunity, and intention to cause a particular type of harm. I want to focus on that particular type of harm for just a second. In policing, there really should never be such thing as a threat generically. It's always a threat of something, a threat of escape, a threat of harm, a threat of death or great bodily harm. And that's because figuring out, under the second prong of that analysis that I talked about before, figuring out the foreseeable effects of the threat presented, whether there's an imminent threat, Sorry, my train of thought got completely derailed. Figuring out whether there is an imminent threat of a particular type of harm becomes important when you try and figure out whether the officer's response, the use of force, was proportional to that threat or not. So just because someone presents some kind of threat does not give officers, obviously, carte blanche to do anything. Their response has to be proportional and appropriate.
And how does that different than the term risk?
Sure. So with an imminent threat, we have ability and opportunity and apparent intention to cause a particular type of harm. Ability is when someone has the physical capability of causing this particular type of harm, right? Someone who's physically running away has the ability to threat, right? The ability to flee. Someone who is holding a baseball bat has the physical ability to hit someone with the baseball bat in a way that someone without a baseball bat obviously does not have the physical ability to hit someone with a bat. Opportunity really refers to whether someone is vulnerable to that particular type of harm. Sometimes it's referred to as jeopardy. Someone who has a baseball bat may have the ability to hit someone with that bat, but if they're 50 feet away from the nearest person, they don't yet have the opportunity to hit someone with that bat. Now, as they close distance and come closer, then sure, they could develop the opportunity, but at that moment, while they're 50 feet away, they do not. And apparent intention is really behaviors indicating that the person wants to cause that particular type of harm. Someone who has a bat and is standing very close to someone else, but they're in a batting cage and he's practicing batting practice, really has no intention to strike someone with that bat. So you need all three to have an imminent threat. When you don't have one of those three things, when you have one or two but not all three, we would refer to that as risk. And officers can use a range of tools to manage risk, but they can't use force to address risk. So if an officer wanted to talk to someone with a bat in that batting cage, the officer might ask the person to put the bat down. The officer might stand on the other side of a fence where they can't be hit with the bat, but they couldn't use force because that person happened to be holding a bat in that circumstance.
You've been discussing this, the standards that sort of apply here to the reasonable use of force. Did you look at Minnesota statutes that deal with the use of force?
I did, yes.
And are they consistent with the legal standards you've been describing?
Yes, there are certainly no inconsistencies. The language used in the state statutes are obviously a little different than language used in the Fourth Amendment case law, but they are broadly consistent, yes.
And did you review Brooklyn Center Police Department policy on the use of force?
Yes, I did.
And is that also consistent with these standards?
Yes, it is.
You mentioned earlier a third step in the process of considering the foreseeable effects of the officer's use of force. Can you explain why that's part of the analysis?
Yes, absolutely. So that gets us into really the fourth step in the analysis. The second step is looking at the threat that the subject presents, if any. The third step, looking at the officer's response. And the fourth step is sort of weighing one against the other, determining whether the officer's response is proportional to the threat being offered. The concept of excessive force, for example, is a way of describing when an officer's use of force is disproportionately high compared to the threat presented by the subject. There are some other factors that go in, but that's essentially the nutshell. You need to figure out what the foreseeable effects of an officer's actions are and weigh them against the foreseeable effects of the threat presented, if any, again, by the subject.
And when you talk about using force and deadly force, is shooting a gun at somebody considered deadly force?
It is, yes.
Why?
The foreseeable effect of discharging a firearm at someone is that it will cause great bodily harm or death. And one of the important things to keep in mind about that is we're talking about the foreseeable effects of the officer's actions, not the effects that actually occur. For example, if an officer shoots at someone but misses, or shoots at someone but causes only a superficial wound, just scratches their shoulder or something like that, we would still consider that a use of deadly force because the foreseeable effect of discharging a firearm at someone is death or great bodily harm. And the definition in policing of deadly force is force that has a substantial likelihood of causing death or great bodily harm.
In the cases that you've been talking about, is there language about hindsight?
Yes. In Graham v. Connor specifically, the court counsels against using what it calls the 20/20 vision of hindsight. That's in the same portion of the opinion where it's reminding courts that are reviewing uses of force that an officer's use of force has to be evaluated from the perspective of the reasonable officer on the scene at the time that force is used, and without adopting the 20/20 vision of hindsight.
In other words, the analysis has to be limited to what set of facts?
The analysis has to be limited to the facts that were available to the officer at the time. You can't bring in facts that are later determined to be true if the officer was not aware of them. So, by way of example, if someone is stabbing at an officer with a rigid, shiny object, and the reasonable officer on scene would think that's a knife, then for purposes of analyzing the use of force, you look at that threat as if it was a knife, even if, after the incident, it's determined that it was really a harmless plastic toy. And in the same vein, if an officer, for example, tells someone to put their hands behind their head, and the person puts their hands behind their head, and it turns out that they have a sword tucked into the back of their shirt, and they're going to whip it out and cut the officer with it, if the officer doesn't know that at the time, then the use of force would be inappropriate, because so far as the reasonable officer and the officer's position is concerned, the person is just complying with exactly what the officer told them to do. So that concept of not using the 20/20 vision of hindsight is really a stern reminder to not bring in information that the officer was not aware of at the time.
All right, now I want to turn to the opinions that you've reached in this case, okay?
Sure.
The first thing I want to go over with you is Officer Potter's use of deadly force. Is her conduct in firing her Glock at Mr. Wright a use of deadly force?
It is, yes.
Why?
Again, firing a firearm, discharging a firearm is substantially likely to cause great bodily harm or death. That is the definition of deadly force.
And in your review of all the materials in this case, did you see any evidence that Officer Potter decided to use a gun in this case instead of a taser?
Did I see evidence that she decided to use a gun? I think the evidence that I've reviewed suggested that she intended to use the taser and not the firearm.
When you're reviewing, then, the use of deadly force, are you reviewing that act or a decision? Does that make sense?
I think so. If I understand your question, it's really what's the nature of the actions that I'm evaluating.
Right.
I am evaluating the use of deadly force because that is, in fact, the force that was used. I separately have an opinion related to the use of a taser, which is what I understand Officer Potter intended to use in this case.
Earlier, when you were describing the standard, in this hindsight 20/20 thing, you talked about what known by the officer at the time. And I meant to follow up on that. At the time of what?
So known to the officer at the time that force is used. For example, just because a person does something at point A does not mean that officers can use the amount of force that would have been justified at point B. The circumstances may have changed. We are talking about dynamic situations. So the question is whether the particular use of force was proportional, and separately whether it was appropriate at the time that force was used.
In this case, have you reached an opinion to a reasonable degree of professional certainty whether Officer Potter's conduct in using deadly force was reasonable and justified?
I have, yes.
And what is that opinion?
The use of deadly force was not appropriate, and the evidence suggests that a reasonable officer in Officer Potter's position could not have believed that it was proportional to the threat at the time. In other words, the use of force was apparently excessive and inappropriate.
And specifically, the use of deadly force.
I'm sorry, yes, the use of deadly force.
In your review of all the materials, is there evidence that Officer Potter herself did not believe that there was an imminent threat of death or great bodily harm?
I apologize. Would you ask that question again?
Sure.
I almost knocked over the monitor.
In your review of all the materials, is there evidence that Officer Potter herself did not believe there was an imminent threat of death or great bodily harm at the time she shot her gun?
Before you answer, excuse me, Your Honor, I object to that. The answer to that is giving an opinion by clients.
Okay, counsel, that's enough. No speaking objections, please.
All right.
The objection is sustained.
In formulating your opinion that you just told us, did you consider whether there was evidence about whether Officer Potter believed there was an imminent threat of death or great bodily harm?
Same objection, Your Honor.
The objection is sustained.
In formulating your opinion in this case, Professor Stoughton, is it necessary for you to determine whether there was an objective, whether a reasonable officer would have objectively believed there was an imminent threat of death or great bodily harm?
Yes.
And would evidence of the officer's actual conduct be indicative of or relevant to an objective standard of whether there was an imminent threat of harm, death or great bodily harm?
It would, yes. The phrase that...
I object, Your Honor. It's asked and answered.
The objection is overruled. You may finish your answer.
Thank you, Your Honor. The phrasing that is used in some of the literature as well as our book is referred to as, confusingly, as subjective objectivity. We're evaluating whether use of force is objectively reasonable, for example, but we do so by taking into consideration the subjective impressions of the officer. Again, that's part of the framework of the reasonable officer on the scene.
And so in arriving at your opinion, was it necessary for you to consider the subjective knowledge of the officer on the scene, Officer Potter?
Yes, it was.
And then in arriving at your opinion that it was not a reasonable use of force, of deadly force, did you see any evidence that would lead you to believe that Officer Potter had knowledge of circumstances that would create an imminent or support an imminent threat of death or great bodily harm?
Objection, Your Honor. Of the opinion of the witness.
Okay, the objection is overruled. I'll allow that. Yes.
Your Honor.
Okay.